Okay, good evening, everyone. My name is Michael Pereira. I'm an attorney with Herzl Law, and tonight we're going to be talking about all things rentals. We're going to be discussing rental requirements, short-term rentals, rental caps, and remedies. So as I said, we're going to start off talking about some standard rental requirements as it applies to the Michigan Condominium Act. Then we'll move into short-term rentals, what are and are not short-term rentals, how those can be regulated by a condominium or a homeowners association. Then we're going to discuss rental caps and how a condominium association can address rentals, short-term rentals through its enforcement powers. So starting off, the relevant portion of the Michigan Condominium Act that deals with rentals is MCL 559.212, which, as I said, provides the minimum rental requirements that must be met for an owner to rent their unit. And before I get to what those requirements are, we're going to test your knowledge first with a little question. So Lucifer, the landlord, is a co-owner in the Renters Paradise Condominium Association. The condominium bylaws are silent regarding rentals. Lucifer does not want to involve the association, and he rents his unit to Party Animal Pete without a written lease. The association's board of directors wants to know the identity of the tenant who is throwing all the loud parties. The association security guard loves to sing "Don't Stop the Party" by Pitbull and does not seem to be much help. How can the association find the identity of the renter and put an end to the parties? Does anyone have any ideas at this point?
My suggestion would be to call the police.
Call the police. Okay, well, let's think of a possible solution short of calling the police. So I'll just spoil the fun and we can get to the statutory requirements, which has the answer in there somewhere. So I'd be interested to hear what you say after seeing these requirements. So under the Condominium Act, first, an owner must disclose their desire to rent their unit to the association at least 10 days before presenting the lease agreement to the potential lessee. At that same time, or soon afterwards, the owner must also supply a copy of the exact lease agreement that will be used, so that way the association can review the lease to ensure that it complies with the condominium documents. What those specific condominium documents require will vary from condominium to condominium. The owner also is required, after the lease is approved, to provide a copy of the executed lease agreement to the association. And then the Condo Act also contemplates a situation where there might not be a formal lease agreement. And if there isn't a formal lease agreement, then the owner has to provide the association with the name and address of the lessee or the renter, the rental amount, the due dates of the rental payment, and how long the rental period is going to be. And just as a note, if a developer owns a unit and they want to rent it, the developer wants to rent the unit, the developer also has to file this procedure. So under the Condominium Act, the association can find out who the tenant is because Lucifer has to, at the bare minimum, if there is no lease agreement, which the hypothetical said, the association is entitled to know the renter's name, address, rental amount, and terms of the rental, both payments and length of the rental agreement. So under the Condominium Act, yes, the association can find out who is renting Lucifer's unit, as well as their name, address, and rental details. So moving on to short-term rentals. Another hypothetical. We're just throwing you guys into the deep end here. So Tranquil Acres Condominium Association was formed in 1985. The condo is 25 units on lakefront property, and the bylaws state that units are to be used only for residential use. The bylaws do not specifically prohibit rentals. Over the past 2 years, investors have purchased 5 units that are regularly listed on Airbnb. Tranquil Acres has turned into Party Acres. Can the association prohibit short-term rentals? Without a specific provision in the bylaws as to short-term rentals, can the association do anything about this? I think I might have stumped everybody with this tough question. Anyone want to take a stab on it? You have a 50-50 chance of yes or no.
Yes.
All right, 1 vote for yes.
I'm going to say yes too. It's a business that's being run because money's being made. And it would depend on what the bylaws state about businesses in the association also.
Okay, that's a good thought, Mary. You're getting a little ahead of me here. Right now, we're focusing on residential use, but if you hold on to that thought in a couple of slides, you might. I don't want to spoil the fun here. So for short-term rentals, there is Michigan case law that says that interval ownership of a unit violates an association's deed restrictions that limit use of property to residential use. So in O'Connor versus Resort Custom Builders, Inc., which is a case from the Michigan Supreme Court, they held that the timeshare use of property was not a residential use. And the case analyzed or came to this conclusion by considering what is a resident. And the Michigan Supreme Court actually adopted the trial court's view and definition of what is a resident. And what is a resident is considered to be somewhere that you have a permanent presence. You might not live there all the time, like you might go on vacations or you might go somewhere else. You don't have to be there 100% of the time, but it's the place that you permanently have a presence for. And it's also a place where you have the right to occupy whenever you want. And the facts in O'Connor, as you can see on the screen, this property was being used for 1-week timeshare intervals. So the people who had a timeshare interest in the property, they couldn't use the property whenever they wanted to. They could only use it for 1-week period. And so that also weighs against a finding of this being a residential use. And finally, when you consider your residence, it's where you have all your stuff. It's where you've got your golf clubs, your hockey bag. It's where you have all your cooking utensils, your pots and pans, your KitchenAid stand mixer. It's where your dog keeps all their toys. So considering all those things together, if it's a short-term rental, those renters don't have a permanent presence at the property. They're not entitled to use it whenever they want. And when the rental period is done, they have to take all this stuff and all their suitcases and they have to leave. So under O'Connor, a short-term rental violates a provision in the governing documents that limit the use of property to residential use. So now we're going to switch it up a little bit. And as soon as I read this, Mary, this is where I'm counting on you to come through for me. So Tranquil Acres Condominium Association was formed in 1985. There's 25 units on lakefront property. But this time, the bylaws prohibit commercial use and do not specifically prohibit rentals. Over the past couple of years, investors have purchased a number of units that are regularly listed on Airbnb, and the Tranquil Acres has now turned into Party Acres. So on the basis of prohibiting commercial use, can the association prohibit short-term rentals in this case?
Here's your business being run, commercial use.
Okay. So Mary was spot on here. In the case from the Michigan Court of Appeals, Eager v. Peasley, the court held that a rental use of the unit, which was listed on homeaway.com, violated the primary holding of the case was that the short-term rentals violated the private occupancy and private dwellings restrictions in the governing documents. The court said that the governing documents require the property to be used only for private occupancy and private dwellings, and by renting the property out, it was no longer being used privately, it was more being offered to the public, and that violated the deed restrictions. However, the court also fell back on the commercial use prohibition, and the court said that even if the governing documents did not limit the use of property to private occupancy or private dwelling, the court would have found that the short-term rentals were a commercial use. And the takeaway from that is, even though it's a home or a condominium unit being rented and being used for residential use, the underlying use of the unit as it applies to short-term rentals was a commercial use, because the owners of the unit were deriving a commercial benefit by renting it out to renters, to lessees, who were then just ostensibly living there. So the court consulted the definition of what is commercial use, and that definition is to be used in connection with or for furtherance of a profit-making enterprise. And then we have a question in the chat from Tracy saying, essentially, aren't landlords renting units a business as well? Yes, it depends a little bit on the nature of the rental. This is primarily focused on short-term rentals. So when you think of short-term rentals, listings on Airbnb where you're renting a unit for a weekend or a week and there's a lot of turnover, that is the commercial business and commercial aspect of it. It's a little different when the lease is long-term, when it's for 6 months, for a year, for multiple years. That's when the commercial aspect of the lease is lessened a little bit, because it's looking more as the occupant is using it more as a permanent residence, as opposed to, and even though there is a little bit, there could be a commercial benefit to it for the landlord or the owner of the unit, it might not be as strong as the case of short-term rentals. Okay, so kind of summarizing it all up on what we just talked about, how can your association restrict short-term rentals in the bylaws for a condominium, or deed restrictions for a homeowners association? One way to do it is to have a residential use restriction where units and lots can only be used for residential use. Another way, and typically these two are used in tandem, is prohibiting commercial use. Other ways to go about it is, as I was discussing in response to Tracy's question, is to have leasing or rental restrictions in terms of length. So the longer a lease goes, the more likely it is the unit is going to be used as a residence as opposed to a commercial business. Other ways to address short-term rentals in your community are nuisance restrictions, so prohibiting activities within the community that are an annoyance or nuisance to the other owners around you. We see this a lot with communities located in nice areas to go for a summer weekend, where there might be loud parties going on late at night. It keeps the neighbors up. There's loud music being played. People are just kind of being rowdy. That could be a way to address some of these rental issues as well. And finally, unlawful activity restrictions. If there is a local ordinance that addresses how and under what terms a unit can be rented, that could be a possible avenue that the association can seek to prohibit these rentals as well. And finally, another thought that could be considered is to prohibit the licensing of units, in addition to having strong and robust rental restrictions. We've seen this a handful of times where someone will be renting their unit on Airbnb, on VRBO, and they'll say, well, I'm not renting my unit to these individuals. I'm just granting them a license to enter and to occupy the unit. And so by addressing, cutting this off at the head and just saying essentially that the association considers a license to be a rental and prohibit it and address them in the same ways. We have a question in the chat from Mary. Says, so we can totally deny any rentals. If that's what your bylaws say, then that is permissible. Within the bylaws, an association's bylaws can definitely say that we do not want rentals. Under no circumstances will rentals be allowed. That is possible. Okay, so one way to address rentals in the community is if the association would like to allow a certain number of rentals, then a rental cap can be implemented. And what a rental cap does is it says that, yes, owners, you are allowed to rent your unit. However, the association is only going to allow X number of units within the condominium or within the subdivision to be rented at any one time. And as long as the rental of your property would not exceed that percentage, then you'll be allowed to rent, provided you comply with the other rental restrictions. And if the number of units in the condominium or in the subdivision is already at that, then we're going to put you on a waiting list, or we're going to say that you can't rent at this time. So that percentage is, we typically recommend between 10% and 20%, up to 30% of the units in the condominium or in the subdivision should be rented. And we recommend that specific percentage because in a condominium, to amend the document, you need 2/3% of 2/3% of all co-owners to approve any amendment. And so by keeping the number of renters under 1/3, then that hopefully fosters an engaged community, and any kind of bylaw amendments or amendments to the master deed would have a fighting chance of being passed. Because if you have 50% renters in the community, then those owners, they're not actively involved. They might be just using their property as an investment, and they don't really care. So they're not going to engage, they're not going to participate, and any amendment will be very difficult to pass. To include a rental cap in condominiums bylaws, the amendment process would have to be followed, which starts off with, as I just said, 2/3% of all co-owners would have to approve it. And then any type of rental restrictions that will be addressed in an amendment are also required to get the approval of 2/3 of the mortgagees, as stated in the Condominium Act. If the developer is still involved in the condominium project, the developer would also have to approve it. And one thing that condominium associations should be aware of is that the Condominium Act states that any rental amendment cannot affect the rights of an existing lease. So one way to address that is with a grandfather clause that essentially says that any co-owner who is currently renting their unit, that will be honored until the lease expires. Once the lease expires, then that unit and that co-owner would have to comply with the new rental restrictions. Or in the event that the lease ends, they would also have to comply if they sell the unit to someone else or just stop renting the unit generally. So as with any amendments, implementing a rental cap may have some pushback. There might be a significant number of owners, over 1/3, who are concerned about what a rental cap would do. If only 10% of units can be rented at any one time, and a concerned owner is like, well, I would be, if I'm the 11th, if my unit would be percentage number 11 and I can't rent, what happens? Like, what happens if I die and my wife can't afford to live there, so she has to move out, and we would want to rent this? There are exceptions to rental caps, and we typically try to include these in any type of amendment where we are implementing a rental cap. Some of these exceptions are death, divorce, financial hardship, medical purposes, where if you have to relocate to a nursing home, you would be allowed to rent your unit. If you have to move for a new job where you have to move out of state, you would be able to rent your unit until you're able to sell it. And then there's the catch-all provision of, if there's a circumstance other than those 4 or 5 very specific exceptions, if there's an extenuating circumstance, then an owner would be able to bring it to the board and say, hey, I would like to rent. I know that the rental cap is here, but here's this very good reason as to why I should be allowed to rent it. The board would then have the ability and the authority to say, yes, we hear you. We're very sorry that you have to do this. For some extenuating circumstance, you'll be allowed to rent, notwithstanding the rental cap. So what happens if there is a violation where either a tenant is doing something they're not supposed to do? How can the association address that behavior? And like before, we're just going to start off with a little hypothetical here. So in the Renters Paradise Condominium Association, it shuts down party animal Pete's late night parties. Pete gets lonely and buys a dog named Trevor. The condominium bylaws do not allow pets, but since Pete is renting the unit without a written lease, he claims that he never agreed to abide by the condominium bylaws. Does Pete have to follow the rules, or does he get to keep little Trevor?
Has to abide by the rules.
Has to abide by the rules. 1 vote for yes. And I'm taking the remaining silence as tacit agreement with Mary.
Depends on what's in the bylaws, because it holds the owners responsible for their tenants and guests.
Okay, that is also a good point. So under the Condominium Act, tenants or non-owner occupants have to comply with all the provisions of the condominium document. And if there is a lease, then that lease or that rental agreement also has to contain that requirement as well. So even though Party Animal Pete didn't have a written lease, he still has to comply with the rules. He can't have little Trevor to keep him company now that all the parties died. Tenants are required to follow the rules. So switch it up a little bit. The Renters Paradise Condominium Association has finally had enough of Pete. Pete has decided to keep his dog Trevor and has resumed his late night parties. The association wants to take action against Pete, and the board of directors is discussing its potential options for how to address Pete's violations. Paul, the president, states that they can only pursue Lucifer, the landlord, for a bylaw violation and imposes fines since Pete is not the co-owner. Sam, the secretary, who lives next door to Pete, says that the association has to do more and must evict Pete. So, Tracy, what can the association do? Can the association only pursue Lucifer because he's the owner, or can the association follow Sam's direction and what she wants to do and evict Pete?
I would think they could evict Pete. He's not following the rules. So I would think they could evict him.
Okay. Let's find out. So under the Condominium Act, the association, when a tenant violates the bylaws, the association must notify the co-owner by certified mail of the tenant's alleged violation. The co-owner will then have 15 days after receiving the notice to investigate the allegations of the violation and have the tenant correct their actions. If after the 15 days, the association believes that the violation is still ongoing, it hasn't been cured, or that it may be repeated in the future, the association can seek to evict the tenant and hold the co-owner responsible for any monetary violations that arise from the breach. So under the Condominium Act, the association can seek to evict Pete, the party animal, as well as if there are any monetary damages that are arising, the association can seek to hold Lucifer, the landlord, as the co-owner responsible for those monetary damages as well. So, keeping on the bylaw violation train, Lucifer, the landlord, is unhappy that party animal Pete has been evicted because Pete can be evicted under the Condominium Act. Lucifer withholds his assessment payments until he can find a new tenant. Lucifer eventually finds a new tenant, follow the rules, Francine, and they agree to rent the unit for $1,000 a month. However, it took Lucifer 5 months to find Francine, and during that time, he has amassed $5,000 in unpaid assessments. The association calls Francine and tells her to make her future rental payments directly to the association to make up for Lucifer's unpaid assessments. Lucifer, on the other hand, tells Francine, don't do that. You have to pay me because I'm your landlord, I'm the co-owner, and you have to pay me. So, who should Francine pay? Should she pay the association or should she pay Lucifer?
She should pay the association.
Agree.
Okay. 2 votes for the association. And you're right. So under the Condominium Act, the association is able to require the tenant of the unit to direct their rental payments to the association if the co-owner is delinquent on their assessments. To do this, the association has to give written notice of the arrearage to the tenant, and the tenant has to either make the payments directly to the association, and if the tenant does not make those payments to the association can either move forward to evict the tenant or follow the proceedings pursuant to the previous section of the Condominium Act, which is also seeking to evict the tenant. So yes, if a co-owner is delinquent on their assessment and there is a tenant in the unit, the association can, by giving written notice of that delinquency to the tenant, require that the tenant make the rental payments to the association until the delinquency is paid. So under the hypothetical, if Francine has a monthly payment of $1,000 and Lucifer owes $5,000, the association can give written notice to Francine saying, for the next 5 months, you have to pay us the full $1,000 payment. And assuming that Lucifer has started making payments since then, she would only have to do it for 5 months, make payments to the association for 5 months. And that is all I have at this point. We flew through this, so if anyone has any questions, I'd be happy to discuss them. If you have any questions, all things rental, feel free to unmute yourself and we can talk.
We're in the process, this is Mary Eastman, we're in the process of rewriting our bylaws now, as Michael, you well know. Anyway, we are tentatively trying to put in there a absolutely no rental clause. The rental clause that's in there right now is stated and was in there precisely for the developer to be able to rent out units to future buyers until their place was built. And so it really is no longer applicable. We haven't had feasibly any renters in several years that we're aware of. And is it hard to sell that to co-owners in the bylaws? Do you have any experience with that? Or is it pretty easy to put that one through?
It depends, as every good lawyer says. It really depends. It depends on the nature of the association. If the association, as you said, is vastly co-owner occupied, then they might be on board with saying no renters. We're used to having a community where we know everyone owns the unit that they occupy, and we want to keep it that way. In that kind of situation, I don't necessarily see any pushback on that. Obviously, people might have individual thoughts and feelings as to that. But on the flip side of that, like if your community is located on Lake Michigan and it's a really popular summer rental destination where owners know that they can rent their unit for 2 or 3 months for weekends at a time and get the money from that to kind of either pay their mortgage for the month or pay their property taxes for the entire year, that might be a situation where there would be substantial pushback as to an outright prohibition on rentals. And that might be a situation where instead of saying no rentals at all, then it could be a situation where you want to restrict rentals a little bit. So you say that there has to be a minimum term. For any rental, it has to be, the initial term has to be 6 months. It has to be a year, in an effort to cut down on those short-term rentals while still allowing some kind of longer term arrangement. So it's difficult to say whether rental amendments would be effective and pass with flying colors, or if there'd be substantial pushback. It really just depends on how the owners in the condominium feel and what they like.
Yeah, we're primarily owner occupied. And like I said, I don't know of any renters at all. I haven't known of any, for the last umpteen years, it seems like anyways. So I'm hoping it's not going to be an issue. But then the issue with rentals comes up sometimes when we have a roommate situation. And is that considered rentals? Are they not? How do you classify that?
Yeah, that's a sticky situation because there are other provisions there are other standard provisions that we usually see in a condominium's bylaws that say that a unit has to be used for single family residential purposes. And what that situation you're getting to with either a roommate or a friend who's just living there is, does that living arrangement constitute a single family use? It could be yes, it could be no, depending on what's going on. If it's a boyfriend and girlfriend living together before they get married, that would seem to qualify as a single family home. If it's a situation where you have 5 college kids who are living together because it's a lot cheaper to rent or to own one property than having everyone have their own place, then that starts to look a little bit different. So in that kind of situation, I would say it's very fact specific as to whether a roommate is a tenant or a renter, as opposed to whether it's more akin to a single family use.
Thanks.
Of course.
This is Melissa Boggs. I hadn't considered roommates before. If you had a co-owner that had, ownership and allowed their, say, son to move into the unit, and he then had 3 or 4 roommates, sharing the cost with them, would that, and how do you handle that?
Again, it's really just fact specific. You have to kind of look at it and make a determination of, is this a rental situation, or is this being used more as a residence with just multiple people living there? I'm just gonna default to it depends, just on all the underlying facts there. And a possible way to look at it is, if the co-owner of the unit is living there and just has a roommate or 2, then that might weigh in favor of this is being used as a residence, as opposed to a rental situation.
Okay. I'm also a little bit confused on what you said earlier about an association can evict the tenant. I was under the understanding that the association goes after the co-owner. That, to the point where if they continue to be in violation and in arrears, that you can take over the unit. I wouldn't think that there would be any kind of contractual way they could go after the tenant. They don't have any relationship with a renter if there's no lease.
Right. So that's where the Condominium Act comes in. And so remember, the Condo Act says that the tenant or the non-owner occupant has to comply with all provisions of the bylaws. So they have to follow all the rules and restrictions that are applicable to everyone else. And if they don't, then the statutory remedy for that and which is also typically mirrored in a condominium's bylaws, is to evict the tenant. And it's essentially that the association has to give notice to the owner saying that, hey, your tenant is breaking the rules, so you need to do something about it. And if you don't do it, then we're going to exercise our right to terminate the tenancy and evict the tenant. So that's the association's enforcement mechanism against it is against the tenant, but it is also against the owner, because the eviction is seeking to enforce the rental or the bylaw provisions against the owner as well, because the owner has to ensure that their tenant is following the bylaws, as well as the tenant making sure that they follow the rules.
So would you go through a typical landlord-tenant eviction where you would present like a 7-day notice or a 30-day writ of possession and include the co-owner as well as the tenant? Or I'm just not understanding the relationship that the association has with the tenant to go forward.
Yeah, so you're exactly right. The nitty-gritty process of moving forward with the eviction is, well, first step is to notify the owner and say that you have 15 days from receipt of this notice to investigate the violation. And if the violation is not addressed within 15 days, or the association believes that the violation will continue, then the association can seek to evict the tenant. At that time, the process for seeking to evict a tenant is to send them a notice to quit, which gives them 30 days to vacate the unit. If they don't vacate the unit within those 30 days, then the association can file an action in the landlord-tenant division of the local court, seeking an order of eviction.
Okay, and the owner doesn't get, their ability to own that unit isn't affected.
Correct. Yes, the association cannot seek to like sell the unit from the owner. You're just terminating the tenancy, and then just no one will live there, and then the owner can seek to rent it out again to someone else, or they can move in and use it as their primary residence. But the eviction action within the confines of the Condominium Act, as well as any kind of eviction in court, does not affect the co-owner's ownership of the unit.
Okay. And then I have one more question. And you mentioned it in one of your slides. It's something that we're in Ludington, Michigan.
Mm-hmm.
So our condominium is, on the water. We do have rentals that are very beneficial to many of the owners. We certainly have some that live here all year round. It's probably a 30% year-round, 30% own it and come up in the summer, and 30% have a mixture of the way they rent their units. But there's a lot of income to be made with it. We are actually talking to you and working through short-term rentals as only a license to occupy. So you don't enter into a landlord-tenant relationship with somebody who is staying under 30 days. A license to occupy gives you the right to evict somebody immediately. It's not, I don't have to go through the court,
Mm-hmm.
the writ of possession, 7-day notice if it's not doing any of it. And I think it protects the association more so than a traditional lease.
Yeah, that makes sense to me. I think you're working with Matt on that specific amendment. So I'm not terribly familiar with it, but it makes sense that if the amendment is going to treat this kind of situation as a license then it might not be a contractual right through a lease agreement where the remedy doesn't have to follow the standard eviction process. Yeah, like I said, honestly, I'm not terribly familiar with that, but if that's what Matt's saying to you and that's the advice you're getting, then I would believe him.
We suggested it to Matt. And there was a situation where a condominium community was prohibiting rentals. One gentleman continued to rent, saying, I don't do rentals, I do licensed to occupy. So that was his experience with it, but we looked at it and said, well, it makes sense to license to occupy if you're going to do short-term rentals, because then you don't have a landlord-tenant relationship.
Okay. So I think that goes back to, it's probably one of these first ones. Okay. Oh. So I think this gets into the final sentence on this page of addressing in the bylaws that a license would still be considered a lease. And so the way that I've seen this play out is more from the owner side rather than the association, where an owner will say, I'm not leasing my unit, I'm granting someone a license to use and occupy it. And so because it's a license, I'm not subject to the leasing restrictions. And that argument is usually tied to either a prohibition against leasing or a 1-year minimum leasing term. And so by saying it's not a lease, it's a license, I can rent my unit for a weekend instead of a year, or I can license it even though leasing's prohibited. That's where I've seen this argument more as a way to get around leasing restrictions, as opposed to, I think what you're proposing is identifying these relationships as a license so as to avoid a landlord-tenant relationship and the remedies that have to follow for that.
It's more restrictive, it gives you more control.
Right. Like I said, I'm not terribly familiar with how that would work and whether that a court would agree with that kind of arrangement. So I would be hesitant to say that that's allowed, but at the same time, I don't have enough information to say it wouldn't work either. I would want to look into it a little bit more, but it's an interesting take on it for the association to use that argument instead of the owner.
Thank you.
This is Kay Peralt. Do you know if real estate agents have an obligation, or do they routinely talk to prospective buyers of a condo about the restrictions? I know a buyer should be looking at the bylaws and know what they're getting into, but we've had 2 situations where the new owner would say, oh gosh, I didn't realize that, or I didn't read all the restrictions. They never say they didn't read them, but you know, and I'm wondering if there's anything an association can proactively do when there are prospective buyers to be sure they know the restrictions ahead of time.
Yeah, the defense of I didn't know I couldn't do that. Yeah, it's so when you purchase a property, you are presumed to be on notice of the restrictions that affect that property. As part of those restrictions are a condominium's master deed and bylaws. So when they buy it, they're presumed to agree to those rules and restrictions. So even if they haven't read it, that's not a viable defense. That doesn't fly. I think your point is more of like, hey, what can we do to make sure that these people actually know what they're getting into? And so I don't have much experience in dealing with like owner relationships pre being an owner and in the like closing process. I would hope that the current owner who's selling would discuss the restrictions with the new buyer and say that, hey, there's all these provisions in the bylaws, and as it pertains to rental specifically, here's the rental restrictions. You have to rent. Any rentals have to be for more than a year, and you've told me that you're going to try to list this on Airbnb, and you might not be able to do that. So I think encouraging the selling owners to have a discussion with their buyers ahead of time would be helpful. I believe I've also seen provisions in bylaws that say that when there is a sale pending, the current owner has to provide copies of the master deed and bylaws to the purchaser. That could be a way to at least try to make sure that the owner has copies of the documents in front of them.
Okay, thank you.
Of course.
I had two questions. The first one was referencing what Mary had talked about. If a co-owner said that they were licensing their unit, wouldn't that would that depict a business? Would that kind of define what a business is? And if there's business restrictions in the bylaws, they would still be in violation. Would that be a
Yeah, that's definitely one way to go about it as well. And there is a recent case out that says that even if an association's documents allow leasing, those leasing provisions have to be read together with the remaining parts of the bylaws. And so even though leasing might be allowed, a commercial use might be prohibited. And so an owner would be allowed to lease subject to the, I guess, frequency of the leasing does not rise to a commercial use. And so that the interaction of those two different types of provisions can be one way that an association can restrict or enforce leasing restrictions against the owners.
But what I was saying is if the co-owner said they were not leasing their unit, they were licensing it,
Mm-hmm.
would that make it, would that pretty much define what a business is? Would he be saying, okay, yeah, I'm running a business?
It's definitely possible.
To get around any rental caps, they could say, hey, I'm not renting, I'm licensing it. Well, if you're licensing it, then you got a business.
Yeah. And again, it's the underlying facts would likely support that it's a commercial use, but it might not. So we would want to just every case is different. Every case has different facts. But I agree with your general thought of, yeah, you're trying to be cute to get in saying that this arrangement is a license and not a lease. But if there's a commercial use prohibition, then that could be another way to cut off that argument and say, okay, you can call it whatever you want. It's still a commercial use.
Okay, my other question was in regards to a co-owner and a co-owner landlord. And so in a duplex situation, you have a homeowner who heavily smokes, and the adjoining owner is a landlord, And he had a tenant in there who had severe asthma, and he they couldn't tolerate the cigarette smoke that was encroaching into this yard. So he had to find her another place to live. He owned multiple units. Now he has had a hard time re-renting it because showing it, you can smell it. And he's asking the association for help. What can be done? The association has addressed the situation with the homeowner. Of course, the homeowner has your typical, I have a right to smoke in my own home stance, but now through compromise, she swears that they don't smoke in the unit. However, the landlord owner said he went over there to borrow something, and the house, just the smell just came out the door. So I don't know. What could the association do, if anything?
Yeah, that's a tough situation. There is case law in Michigan that says if a condominium's bylaws do not prohibit smoking, then smoking is deemed to be allowed. So it might not be a bylaw violation where you can address the smoking at the root cause by requiring her to stop smoking. This might be a situation where you have to get a little creative and work with that owner who is smoking and say, we appreciate that you have the right to do this, but it's bothering your neighbor and it's bothering your neighbor's tenant. What about maybe installing some air purifiers or trying to do something to minimize the smell? It could also be a situation where if this owner's been there for years and years, the smell of smoke is just there and there's really nothing to do about it to get it out, or to her current smoking isn't really having an effect. It's the years of smoke buildup that's in the walls, it's in the carpet, it's in kind of everything.
That's a fairly new owner, and unfortunately or fortunately, our bylaws also state that you're not permitted to do anything that is loud or obnoxious odor and a few other things in the bylaw. So that's why he's coming to the association. Now, I remember there was a court case where the judge had ruled, the court had ruled that it was an owner versus owner situation and not an association versus co-owner situation. But I don't remember what the name or what the details on that case was. Do you know what I'm referring to?
That specific information doesn't sound, it's not ringing any bells. The case that we usually use for smoking issues is called Davis v. Echo Valley. It's from the Sixth Circuit of Michigan, so or Sixth Circuit in Michigan, so it's a federal court case. I'd be happy to send that to you. If you want to send me an email, I can forward that to you and look for the specific case you discussed about if it's an owner versus owner issue, as opposed to the association having to step in and having an obligation to enforce the rules. And if I can get to the last page, it should have my email. There it is.
Yeah, I got your email. I'll send you something.
Okay.
Thank you.
Yeah, of course.
And can I get a copy of today's presentation as well?
Yes, I can send you a copy of this, and this presentation is also being recorded. And so I believe that the plan is to post this on our YouTube page as well. So if you want to go back and listen to me, you can. Otherwise, I'd be happy just to send you the slides and spare you that pain.
Okay, thank you.
Of course.
I have a question for you. Is there like a state board, a consortium or something that deals with HOA rules and condo rules and things like that, that either, you know, condo board members or condo owners or with lawyers and other things get together and discuss things? Or is this, you know, just that you're not aware of one?
Yeah, so there is a national group. It's called the Community Association Institute. It's CAI. And that is, like I said, it's a national group where it's lawyers, it's property managers, board members are invited, but it's typically the first two, attorneys and property managers, where we discuss what's going on. There's seminars that are presented. There's annual conferences. Myself and a handful of our other attorneys went down to New Orleans in January and attended a CAI conference. So yes, there are, I guess, at least one national group that's very well known. It's very active, and that is, again, Community Association Institute. I believe their website is caionline.org. And they have a lot of publicly available information that could be helpful for you and for any other board members.
Thank you.
Yep. And then there is also like more geared towards attorneys. In Michigan specifically, there's a real property law section that does address condominium and HOA issues, but again, that's more geared towards lawyers, and the condo and HOA side of it is part of it. It's not the entire focus.
And then your guys' previous seminars are posted on YouTube or on your website or something, aren't they?
Yes, they are on our YouTube page, and I believe that you can get to the YouTube page through our main website.
Okay.
There should be a link to it.
You guys have done just a various amount of topics, and they've been so useful. So I appreciate that so much. Thank
you. Yeah, we try to put these on as often as we can and hop from topic to topic. This All Things Rental is it's a presentation I've done before, the presentation other attorneys have done before, because rentals it's an issue that comes up a lot. So we have the YouTube page with past recordings of seminars. We also have our blog that has just individual blog posts about mostly any type of topic you could ever care to read about. So I appreciate the kind words. Does anyone else have any questions?
This is an off the topic one, but you guys have a new edition out to the Herzl Law Book. And the initial edition was available on Amazon, but the second edition, I don't believe, at least I tried to get it the other day and I couldn't get it. Do you know if it will be available?
It will be available. This is the second edition. It's 160 some pages. It should be available on Amazon. If not, if you don't see it, Mary, give me an email and I can put you in touch with someone in our office to make that happen.
Okay. All right. Is it also available through Kindle? Do you know?
I don't know.
Okay.
I can find out though.
Okay. Thank you.
Of course.
This has been great. Thanks.
Oh, well, thank you. I appreciate everyone sticking around and playing Stump the Lawyer. It's a lot of fun.
Thank you. And you have a nice holiday weekend.
Oh, thank you. You too. So if there's no other questions, I think I'm going to end this. I want to say thank you for everyone for attending. I really enjoy putting these on and engaging with everyone and being able to see familiar names. And so thank you for sticking with me. I hope everyone has a happy and safe Memorial Day weekend. And if you have any questions that you would like to talk to me about, my name, email, and our phone number is on the screen. Please feel free to give me a call or give me an email.
Thank you.
Thank you all.